meeting that we will have the chance to participate thanks to the entrepreneurship spirit of the law office of Vásquez, Urra, y Abogados, and also a joint venture we have formed with the University of Chile Law School. This is a great value kind of encounter, and I'm sure all the persons that participate will become enriched with what they are able to learn today. We also thank the Center of Arbitration and Mediation with Chilean and the Santiago Chamber of Commerce that is also participating in this activity, a center with which we have strong links. Several of our graduates participate as active arbitrators in this organization. As you know, alternative mechanisms for solving conflicts have many advantages. They are more efficient, they are faster, they give better use to resources, and sometimes they are able to solve conflicts in a much better way than going through the traditional judicial process. One of the forms that is most efficient in this alternative mechanisms for solving conflicts is certainly arbitration. Arbitration is used in the international area or sphere of the law, also in public and private law, in labor law, in merchant or commercial law, among other areas of the law. In commercial international arbitration, the parties that intervene are from different countries, and tribunals or courts in this type of cases, it's quite common that they prefer arbitration because of the need to have a tool that is efficient for solving this type of conflicts. And this is why, since the New York Convention was adopted in 1958, has gained a great consensus and has become a practical means for arbitration decisions to be recognized and enforced. In our country, in Chile, there are several moments uh, that are important in terms of arbitration. For example, the Convention of New York was adopted by law in 1975, and we also follow a law that was enacted on the year 2004, the Uncitral model of commercial international arbitration of 1985. This is why the interview and the subject that Mr. Ricardo Vásquez Urra will touch with the great professor on arbitration, Gary Bourne, is for us in Chile of great importance. Ricardo Vásquez is a lawyer. He's a graduate from our law school. He's got a master the University of Sydney, Australia, and has specialized in arbitration, corporate law, and investment, as well as he has participated in the negotiation of free trade agreements, and since 2017 is listed in the arbitration panel of the International Center of Differences, that is known as CIADI, and since 2020 in the Commission of Arbitration of Beijing. Our star today, and I'm just coming to the end of my presentation, is the great lawyer and professor Gary Bourne. He got a Juris Doctor from the University of Pennsylvania. He works in London. He works for the law firm, a famous law firm of Wilmer, Cutler, Pickering, Hale, and Dorr. And he's been a professor and taught in several law faculties in Europe, Asia, and America. And he's been a lawyer in, many arbitrations, more than 100 arbitrations, and participated in some of the most important arbitrations that have taken place most recently. He's also an author who's published major books on this subject matter, such as International Arbitration Law, Law and Practice, its second edition, the year 2016, and also International Civil Litigation in U.S. Courts, the sixth edition, 218, and probably, most likely, he is mostly recognized by his monumental and major work, International Commercial Arbitration, published for the first time in 2009 in 2 volumes. And today, or let's say the year 2020, it's a work that has 3 volumes already. It describes and introduces all the most important matters of arbitration, the annexes, and all you can find there in this book everything a practitioner may need to pursue a commercial international arbitration. It is for sure the main treaty on this subject matter at present. I was a student, Professor Michael Riesman and Professor Mirjan Damaska and Professor Owen Fiss at Yale Law School. So I have conflicting views about arbitration. Sometimes, some days, I wake up and I say, we should follow arbitration and look for it as much as possible. And this is when I'm hearing the lessons I learned from Michael Riesman, who has participated in several ICG arbitrations. And other days, I hear the voice, a strong voice, Professor Damaska and Owen Fiss, who wrote this famous piece against arbitration. So I'm in between those 2 worlds, Professor Bourne. I'm very interested in hearing you and hearing this conference, and I must excuse because I cannot remain during the whole interview, that I may watch afterwards, because I have our responsibilities as a dean, but I will hear you for some minutes. And again, I thank Ricardo Vásquez, his law firm, and the Center for Arbitration of the Cámara de Arbitraje de Santiago. All the best wishes go from me to the participants in this seminar, and thank you so much for your patience in hearing my words. Thank you.
Thank you.
Thank you. Thank you, Dean. Please, Macarena.
Thank you very much, Ricardo. Well, first of all, welcome everyone that has joined today this Zoom, this great interview to our arbitration leader, Gary Bourne. And thank you to the Dean and to Ricardo Vásquez to make this possible today. For us, it's a very special moment. All who works and wants to develop more, to have a better access to justice to our country, this is a very, very special moment. Just a few words. The Dean has said a lot, and I agree with him in every part of the speech. But Gary, just to let you know that throughout its history, the Santiago Arbitration and Mediation Center, we call CAM Santiago, has entered into cross-institutional, practical, and academic cooperation agreements. One is with my own university too, Universidad de Chile, and a lot of others, both here in Chile and out of Chile and other countries, with various national and foreign institutions, with the aim of promoting and perfecting the appropriate mechanism for the peaceful, I think peaceful is the word, resolution of dispute and the best international practice. In 2009, as part of a steady strengthening of their international presence, the Santiago Arbitration and Mediation Center, CAM Santiago, signed a cooperation agreement with SIAC, your center, the one that you preceded many years ago, with the purpose of first recommending mediators and arbitrators between the centers upon the request of the other institution, and second, to organize a conference or seminars of mutual interest, and at last but not at least, sharing best practice. In early December 2020, SIAC announced the opening of the SIAC Americans Representative Office in New York, the SIAC's first representative office outside of Asia, as well we know, and SIAC's fifth overseas representative office. Recently, in the development and implementation of SIAC's initiatives in the Americas, representatives of both centers, institutions have been holding meetings in order to update the collaboration agreement and sign a new memorandum of understanding, made and sharing knowledge in digital matters. For example, you know that CAM Santiago work a lot in a work group in APEC, developing ODR, online dispute resolution. And we are the first center to show a small, I think, project in this matter. So I think there is an institutional global recognition that CAM Santiago has earned through its digital platform too. We had the eCAM Santiago since 7 or 8 years ago. And the develop, as I told you recently, is the new platform of online dispute resolution called ODR CAM Santiago. This key milestone will reinforce the commitment of both institutions to jointly promote the benefits of mediation and arbitration now in this digital age. The work meetings of the last weeks have been possible thanks to the participation of these following people. Mrs. Adriana Uson, she's the head of SIAC's American office. Eugenio Gomez Chico, the deputy head of SIAC's American office. Elena Merimishkaya, she is a very well-known Russian arbitration that she lives with us here in Chile, and she is an academic and consul of CAM Santiago. Laura Aguilera, she's the head of studies and international affairs. She has been at Japan, for example, knowing and learning about ODR and technology involved in ADRs in general. Benjamin Astepe, who is in charge of developing ODR in CAM Santiago and who speaks now. So thanks for the trust of your center in CAM Santiago. This is a new door that opens for us, not just for the center, but also for everyone that works there and all the lawyers here in Chile that wants to give the people that comes through us a better way to resolve conflicts. Just I think in mediation and arbitration is a good way to begin. So thank you again, Gary, nice to meet you. We were 3 years ago on Peru, and I hope this is one of our future meetings, and I hope to be there in your center and to have you here in Chile with us. Thank you very much, and congrats, Ricardo, for having here us today.
Thank you.
Thank you, everybody. Well, thank you, Dean Ruiz-Tagle, for your opening remarks and your support for this activity. Of course, I want to thank to the Santiago Arbitration and Mediation Center, in particular, Macarena Letelier and her team for their continued support and developing arbitration in Chile. I would like to thank as well to Mr. Francesco Cámpora, Universidad de Chile professor, ICC member, partner of Loy Letelier Cámpora, who is going to take your questions, and to Idealex Press for broadcasting this event. Well, greetings everyone. Welcome to this conversation with Gary Bourne. Thank you for joining us, and I hope everyone, of course, is safe and healthy. Hi, Gary. Welcome. How are you?
Thank you so much for that kind introduction and for inviting me here. It's a real honor and pleasure to be with you tonight, even if only virtually. Thanks also in particular to the law school, the University of Chile Law School, the Dean, Magdalena, you, Ricardo, and Francesco. I know you personally took time and effort to make this possible, and I appreciate it. Perhaps most importantly, thanks to all of the attendees, the viewers, who I'm sure have other things to do. We're all working from home, I suspect, or something like that. And I know I speak for everybody here. We appreciate very much your being with us tonight.
Excellent. Thank you to you, Gary. I'm wondering, you have more than 30 years of working experience, but I'm wondering, why did you get involved in international dispute settlement? Why did you choose international commercial arbitration over other fields?
That's a good question. It might be that I had great difficulties finding other employment in my early years, and I was left with no other alternative. It might also be that I had a foreign wife and was accustomed to international disputes, and arbitration therefore came quite naturally to me.
All right. Yeah. Okay. That's good to know. So we know that you act both in arbitration and in litigation, whether domestic, international, cross-border, of course. And arbitration is a tailor-made procedure, granting, of course, the parties to the opportunity to manage it. But do you think that arbitration is a fairer field than litigation?
I think that's an excellent question. It's one that I know businesses ask themselves, in a sense, every day. The dean, as he mentioned, asks himself that question every morning. I think it's difficult to have a categorical answer that in every case arbitration is better than litigation. In some domestic matters, for example, there may be advantages to national court litigation. There may be, in some international contexts, perhaps some lending transactions where a financial institution wants a particular type of proceeding that litigation would have benefits. As a general matter, though, and obviously subject to exceptions, I believe that international arbitration, put aside for a moment domestic arbitration, is preferable in the vast majority of cases to the alternatives, in particular to litigation in national courts. The dean touched on a couple of these points, but in my mind, the advantages of international arbitration can be summarized by what I call sometimes the 6 E's. Arbitration is more efficient, more expeditious, more expert, more even-handed, more enforceable, and today more electronic than the alternatives, than litigation in national courts. In many ways, that is because arbitration is both a consensual process, parties agree to arbitrate, but also because of the character of arbitration. What is arbitration? Arbitration is a means of resolving disputes by an adjudicator, a decision maker chosen by the parties, typically after a dispute arises. It also has a flexible procedure designed largely by the parties, but in some cases through the procedural discretion of the arbitral tribunal. As a consequence of those basic characteristics of arbitration, it can be both more efficient and more expeditious because the parties are able to choose a decision maker who is familiar precisely with their area of dispute after that dispute has arisen. They can choose someone who, because of language, because of legal qualifications, because of past experience in a commercial or a technical field, is familiar with the dispute and able, therefore, to design a procedure, preside over a procedure that is both more expeditious and more efficient. Additionally, arbitral institutions in this era have designed so-called expedited procedure rules. The SIC, the ICC, other leading arbitral institutions have done so, enabling quite significant disputes of up to around $5 million US, to be resolved in no more than 6 months. And as we all know, in litigation, in arbitration, time is money. And therefore, having a dispute resolution mechanism that is efficient and expeditious means that the businesses ultimately save money. Those same characteristics make a dispute resolution mechanism that is more expert. You can choose the arbitrator after one knows, for example, that this is a joint venture involving telecommunications in Kuwait and the language of the arbitration is Spanish. You can choose an arbitrator who has precisely, an arbitral tribunal with precisely the relevant expertise. Arbitration is also, and this is especially true in international matters, more even-handed. In a typical international litigation, both parties will seek to litigate in their own home jurisdictions because, often correctly, they think they have an advantage there. Both parties often will go forward on their own home turf and, in a fair number of cases, obtain favorable judgments. The only advantage to that unhappy picture is that those judgments typically can't be recognized or enforced in one another's home jurisdictions. In contrast, international arbitration doesn't involve dispute resolution on one party's own home turf, but instead a neutral and even-handed international forum with arbitrators who are required to be both independent and impartial, with good mechanisms for challenging and removing them if that is not the case. Because of the New York Convention and the UNCITRAL model law, which we've heard reference to already, both international arbitration agreements and arbitral awards are also subject to easier recognition and enforcement than either forum selection agreements or national court judgments. There's an enforceability premium, which means that once the parties have resolved their dispute, that dispute really does stay resolved.
I would like to talk to you, Gary, about the New York Convention, as Dean Ristaglia as well touched that point. But it's interesting your comment regarding the expeditions of arbitration. And one of the issues usually raised by clients is the cost of arbitration. Having the ICC rules, the SIAC rules, some other institutional rules incorporated fast-track proceedings, but used for smaller value disputes. Do you think those faster proceedings maybe could be used for bigger cases?
It's possible, and in some cases, the SIC rules permit fast-track proceedings in cases, for example, of exceptional urgency, even if they're larger value. One has to be careful. One always must give parties an opportunity to be heard to ensure basic due process rights. And therefore, if you have a $500 million dispute, a $2 billion dispute, if you have a dispute that involves state entities or important matters of principle, one doesn't necessarily want to be too expeditious. Parties themselves often in those cases, notwithstanding wanting to save money, prefer a more deliberate procedure where they're ensured that they have a full opportunity to present their case. I would like to go back to your first question just very briefly though, because I missed out both the 6th E and a short comment I wanted to make about Professor Fiss. The 6th E, of course, is that international arbitration these days is more electronic than the alternatives. Remote hearings, virtual hearings have become the rule in most parts of the international arbitration world, whereas in many national courts, judges have struggled, I think, with the new technology. That's particularly true in jurisdictions where, for example, there's a jury trial. But even in other jurisdictions, there has been a significant challenge with remote hearings. And thus, I think it's fair to say that international arbitration has become more electronic as well. The final I'd like to make about Professor Fiss, who the dean sometimes wakes up to, and which is with good reason, because he was a formidable figure. His famous article was called Against Settlement. And Professor Fiss's idea was that when private parties took their disputes off and settled them out of court, they were actually doing something that was somewhat illegitimate, a little bit selfish perhaps, because they were denying the public a public good. They were denying the public the benefit of a judicial decision resolving their dispute and thus making law on which everyone could rely. Professor Fiss, therefore, was also against arbitration because many arbitral awards are not published, and therefore by resolving your disputes by either arbitration or mediation, one again steals from the public in a sense. One takes away the opportunity for a judge to make some law. That view, I think, really misunderstands dispute resolution and adjudication. I think that's particularly true in a civil law jurisdiction where a civil code is supposed to be the law, but it's also true even in common law jurisdictions where much law is made by courts. Courts these days don't have too few cases to make law. If anything, in most common law jurisdictions, they have too many cases to make good law. And as we all know, if courts are overburdened and act too hastily, the law that they make is actually bad. Unsurprisingly, that's why almost all judges in common law jurisdictions disagree with Professor Fiss. They think there should be alternative dispute resolution, both mediation and arbitration, to relieve the congestion in their dockets, precisely so that they can take the opportunity in the appropriate number of cases to make good law. But finally, and perhaps most fundamentally, I think Professor Fiss misunderstands the rule of law. One of the most fundamental aspects of the rule of law is the autonomy of parties. It's that autonomy, the freedom of contract, the freedom of religion, the freedom of marriage, that lets people form relationships in the first place. All free democratic societies recognize that freedom. And yet all those relationships, because we're only human, have flaws. They encounter difficulties, disputes arise, like the marriage that I referred to in answer to your very first question. A fundamental aspect of human freedom, of autonomy, is not just to make relationships, but also to mend, to cure relationships, to fix them when something goes wrong, through the party's own free choice. That's what arbitration is, as we started out by saying, the right to choose how your dispute will be resolved. The people who arbitrate or who mediate or who settle aren't robbing from the public. Instead, if one were to take that freedom away, it would be the public robbing from them.
Yeah, definitely international commercial arbitration has proved to be a very successful way to solve problems between private parties. And as Dean Ruiz-Tagle mentioned it as well, the New York Convention has proved as well to be a cornerstone in international commercial arbitration. You know, Gary, that there have been proposals in the past urging to amend it. And I should say that the saying goes, if it ain't broke, don't fix it. What is your view about that?
So you stole my answer. This answer to my previous ones will be short. The convention now is essentially global. Iraq ratified just in the last weeks, making it the 168th contracting party to the New York Convention. There are a few outliers, North Korea, and I'm not sure who else, but essentially the entire world has ratified the New York Convention. I also believe that through the joint efforts of parties, of counsel in arbitrations, of national courts, of writers, commentators, the convention has been elaborated in a very useful way. I think it has faced unforeseen challenges, unforeseen issues that when the convention was drafted and they referred to things like telexes in Article 2.2, nobody could have foreseen. And I think that's really why one shouldn't try to fix something that isn't broken. I worry that the fix might end up looking something like Article 17 in the 2006 UNCITRAL model law, namely a very lengthy, overly detailed set of provisions that by definition almost can't accommodate unforeseen future circumstances. So I would wholeheartedly endorse your observation. If it isn't broken, please don't fix it.
All right. You mentioned it, the 6 E's, and among them you said electronic. And after 10 years of wider use, the International Bar Association updated its rules on taking of evidence in international arbitration. From my perspective, the updates to the rules are predominantly intended to, in some way, reflect the practices that have been adopted by parties and arbitral tribunals since the COVID-19 pandemic began. What are your thoughts on this new set of rules, Gary?
I think what you said is exactly right in your question. I think the principal contribution, first of all, I think the IBA rules on the taking of evidence are a quite good thing. They are also not broken, but I don't think that the 2020 fix, if I can put it that way, was damaging. And on the contrary, it's part of an evolutionary process reflecting best practices, which I think was in fact desirable. I think under the previous rules, the IBA rules on the taking of evidence, remote hearings could be accommodated, but obviously nothing specifically addressed them. I think that the new provisions reflect best practices, which remarkably over the past year developed almost spontaneously around the world in a very positive fashion. I think if you'd asked the various attendees on this webinar 2 years ago, could you have remote hearings? Is it likely we might have a calendar year where there are really only remote hearings? Everyone would have thought it was a ridiculous question. They would have thought that couldn't be done, and why should we? I think today the answer is exactly the opposite. I think remote hearings have been used quite effectively by parties from many different jurisdictions. I think that in a vast range of different types of disputes, remote hearings have proved capable of not just resolving disputes when you can't have an in-person hearing, but also resolving disputes more efficiently and expeditiously, even if you could have an in-person hearing. I think the real question will be, once we can travel and all spend a week or 2 weeks together in the same hotel in Paris, in London, in Miami, in Santiago, will we in fact do that? Or will we continue to use remote technology with the benefits that it produces in terms of time and cost? I don't know the answer to that, but I suspect we'll have more remote hearings than we would have imagined possible not too long ago.
Mm-hmm. And what about the Prague rules of conduct of proceedings? I heard that you are not a big fan of these rules. Why is that?
So the Prague rules have a noble aspiration. They're, as you mentioned, titled Prague Rules for the Efficient Conduct of International Arbitral Proceedings. And obviously we're all in favor of efficiency. In my view though, and perhaps to be fair, this might reflect, my practice is a complete blend of common law, civil law, international law. So I'm not sure I'm all that much of a common lawyer, but if I do have a bias, it probably reflects my common law training. And I consider that the rules predisposition against any sort of disclosure, but especially electronic disclosure, is out of keeping with both what businesses often want. They may not say that at the very beginning of a case, but in the course of a case, they almost always want some opportunity for disclosure to test the party's factual assertions. And also with one of the fundamental objectives of arbitration, which is to resolve disputes in accordance with the rule of law. In order to do that, one needs a sound, a true understanding of the facts. In my experience, in major disputes, a measure of disclosure, not going overboard, but a measure of disclosure is essential to that. Parties are capable, their lawyers are capable of telling very beautiful stories, but a little bit in again, in my experience, sometimes like Potemkin villages, where if you probe a little bit with the benefit of disclosure, those stories come apart. And at the end of the day, what tribunals are mandated to do is to resolve disputes, factual disputes. And in my view, disclosure is an essential part of that. I think the Prague rules have gone overboard, perhaps, in trying to realize some efficiencies in the arbitral process.
Mm-hmm. As arbitrator, of course, you know that soft law is quite important. But as arbitrator as well, you have been subject to disqualification by one of the parties. I remember an exit case where Spain sought your disqualification. ICSID and UNCITRAL have been working jointly in a code of conduct for adjudicators. Do you think, Gary, that a code is the way to deal with issues such as, for instance, independence and impartiality, or the current regulation within rules and conventions are enough?
Yeah, that's an excellent question. And I think I'm a little bit like the dean on this question. I wake up with a different view on this topic on different days. I have in the past been rather critical of the IBA guidelines with their traffic light system, the red list, 2 red lists, orange list and the green list. The main reason I've been critical is because I think the IBA guidelines muddle the requirements for disclosure with the requirements for removal or disqualification of an arbitrator. And I think it's extremely important to keep those two things different. There should be a much broader obligation of disclosure than would be sufficient to disqualify an arbitrator, to remove an arbitrator for lack of independence and impartiality. I am skeptical, I have to say, as to whether the UNCITRAL ICSID guidelines or rules for adjudicators will produce a positive result. I'm skeptical because, a little like the case of counsel ethics in international arbitration, I think the problem with arbitrator independence and impartiality is not the lack of standards, but instead the existence of too many standards. And in my view, the UNCITRAL ICSID rules will likely add just another set of standards that will produce more uncertainty because of potentially conflicting or inconsistent standards. I think that confining rules to a specific type of arbitration, and in that context, further elaborating the obligations of independence and impartiality, is in contrast a good thing. By that I mean, and to some extent, the IBA guidelines themselves recognize this, and a recent decision by the UK Supreme Court, the Halliburton case, also recognized this, but parties in different commercial sectors have different expectations as to their arbitrators' independence and impartiality. Also, frankly, parties in different countries. Parties in maritime cases, for example, very frequently expect arbitrators to have had very large numbers of repeat appointments, hundreds of repeat appointments by not just the same law firms, but the same parties. And that's very different to your ordinary non-maritime commercial arbitration case. ICSID cases may also be somewhat different. Investor state cases may be somewhat different, although I think it's worth thinking hard about whether that's really the case, given the extent of repeat appointments there. I do think, and going back to the challenges that are sometimes raised against arbitrators, I do think there's a real cost to excessive challenges. Many challenges, the one, for example, that you mentioned by Spain, are rejected. Many challenges are made, quite frankly, I think, without any expectation that they will succeed. They're made for tactical reasons, to have a hearing postponed, to to lay down a marker with respect to a particular arbitrator, perhaps for domestic consumption or internal consumption at a particular party. And I think measures should be taken to discourage those types of challenges, guerrilla tactic challenges. And in my view, the imposition of costs, an immediate costs order, an interim award of costs with respect to meritless challenges in the course of an arbitration is something that should be seriously considered.
And so what about double hatting? Should be allowed? Should it be forbidden maybe, or just from your perspective, better than late?
So double hatting is referred to, and you can also have triple hatting, to be honest. The double hatting refers to the practice whereby the same person, say me, both sits as an arbitrator and acts as counsel. Not, of course, in the same case, but just in the course of one's career and at the same point in time. So at one point in time, I'm acting as counsel, and then the next day, or maybe later the same day, I'm sitting as an arbitrator or preparing for a hearing as an arbitrator. The third hat I referred to is being an expert witness. In addition to being an arbitrator or counsel, you can also serve as expert witness, which has a slightly different mandate, a slightly different set of expectations than either arbitrator or counsel. Let me start by saying I think there can be very substantial benefits from double or triple hatting. I think that many younger arbitrators are almost inevitably counsel. I think it would be a very unfortunate thing for both the development of arbitration practitioners, the development of individual legal careers, the efficient handling of cases, to say that all arbitrators may not be counsel, because you would therefore essentially be reserving the role of arbitrator to older practitioners, often these days older men. And I don't think that is a desirable approach either today or in 10 or 20 years. I also think double hatting benefits the people who do it as both counsel and arbitrator. You don't really understand how counterproductive some procedural tactics as counsel can be until you've seen them displayed before you when you're an arbitrator. One is a much better counsel if one has been an arbitrator, and conversely, one's a better arbitrator if one has recently been counsel. One understands the procedure.
Yeah.
Of course, in some cases, investor state cases being an example, there may be risks from double hatting. The risk is that if one is an arbitrator in a case that raises very similar issues to a case where one is counsel, then one might be tempted, notwithstanding one's obligations of independence and impartiality, to skew one's decision in the arbitration in order to favor one's client in the case where one's counsel. To be honest, I think that as a practical matter, that's very unlikely to happen. It's very unlikely that somebody writes an award on the basis that they subsequently cite it in their favor in some other case. Nobody is going to attribute much weight to an award written by counsel for one of the parties, particularly not if it was in the recent past. Nonetheless, perhaps in order to ensure confidence in the arbitral process, there should be disclosure and other limitations on serving as arbitrator and counsel in investor state cases involving similar types of instruments. I don't think Untitled and ICSID have decided how they want to approach the issue of double hatting, but I think in light of its very important systemic benefits, one ought to be hesitant about imposing restrictions.
I want to move to investment arbitration, but your words reminds me, or your opinion reminds me some words that I heard from Yves de Reins, who says that, I'm going to paraphrase this, of course, that the ability to decide is not really skill. It's that one learns during law school, for instance, or training courses, but it is rather a skill that is developed through practice, is developed through self-assurance. What would be your advice, Gary, for those arbitrators who will be appointed, who are going to be appointed for the first time?
So the first time, getting your first arbitration, like catching your first fish or buying your first car, is the most difficult one, always. And just getting into the position to face the question that you raise is a difficult one. I think serving as tribunal secretary is a good way to assure yourself of that first appointment. I also think that many arbitral institutions, SIAC, for example, have a reserve list for smaller cases or appointments on behalf of parties in smaller cases who have defaulted. And I think young practitioners can and should seek to be appointed as arbitrator in those types of cases. They often don't involve much by way of remuneration. They're good opportunities for younger lawyers to get their first experience. I do think also as well, serving as tribunal secretary, but also serving as counsel and watching how tribunals decide your cases that you have argued is a good way to answer Eve's question or to approach the conclusion that Eve offered. I think watching how a tribunal decides both procedural matters in the course of the arbitration, but how it decides in its award is part of the process that he referred to. It's also one of the reasons, again, that I'm doubtful about prohibitions against double hatting as a general matter.
Mm-hmm. Excellent. So regarding investment arbitration, the foreign investment regime, that has been subject to increasing criticism. The EU has pushed the introduction of this investment court system for the resolution of investment-related disputes, basically which emerges features of arbitration and judicial settlement. What do you think about this proposal?
I think it is deeply pernicious and would be an important step backwards, perhaps a century backwards, to some of the darker chapters in our history of international law. I think it replaces a system which is characterized by independence and impartiality of tribunals who are chosen through the equal participation of both parties, with a system where one party alone, and predominantly the European Union, would choose all the decision makers. The host state would choose all of the decision makers. If you dig not too deeply into the reasons for the multilateral investment court, those reasons are quite simple. States want to win more cases. They want investors to be unsuccessful in a higher proportion of cases. The way they seek to do that, and it's important to think about why they want to do that. They want to do that because now European Union states are, for the first time in the last decades, on the receiving end of claims by foreign investors, rather than being the state that is the home of the investor making claims against countries, whether in Latin America, Asia, or elsewhere. And the way that the European Union in particular wishes to win more cases is not by changing the substantive protections in bilateral investment treaties, which they could do, but through the indirect mechanism of asserting complete control over the selection of the members of the court and control over the compensation and the reappointment of members of the court. I don't think that speaks well of the European Union. I think history will judge that sort of mechanism quite adversely. It's important, as well as we think about that, to remember that the multilateral investment court is not something like, say, the Privy Council in England or your highest court in Chile, which hears a wide range of issues on every conceivable topic. Instead, the Multilateral Investment Court hears an extremely narrow range of issues, and to allow states to pick alone all of the members of a court based on that narrow range of issues amounts in many ways to the states deciding the disputes themselves, which is a very unsatisfactory approach towards international law.
And regarding Latin America, what do you think may be the main challenges for a positive evolution of international arbitration here in Latin America?
I think in many ways there has been a revolution. You Ricardo, I think can speak to this more expertly than myself, but I think if you look at the last, I don't know, 2-3 decades in Latin America, there has been a revolution already. And I think the real challenge is sustaining that revolution. I think every country faces different challenges in that regard, but I also think that there are global challenges that have arisen in the last 10 years, which then manifest themselves in specific ways in individual countries. In the United States, one has seen the Trump administration demand the renegotiation of the North American Free Trade Agreement and the significant curtailment of investor-state arbitration. Also, the abrupt withdrawal from the Trans-Pacific Partnership negotiations in significant part because of the investor-state protections. One will no doubt see introduction of legislation in the Democratic Congress aimed at curtailing arbitration, particularly in domestic matters in the United States. Similar developments, perhaps worse in some ways, have been manifested in the European Union. And in each case, I think the common theme, the extreme right and the extreme left of the political spectrum, see arbitration, both investor-state arbitration, but also commercial arbitration, as a threat to state control, a threat to the ability of the state to monopolize all aspects of both commercial, but also human affairs. How one addresses that, I think, how one meets those challenges depends significantly on individual jurisdictions. But the answer for Chile is different from the answer in the United States or Mexico or elsewhere. But I do think it is important, not just for arbitration, but more importantly for liberty, for human freedom, for civil rights, that those challenges be met.
Unfortunately, we don't have too much time, but I would like to ask you, a couple of weeks ago, we learned of the death of Professor Emmanuel Guillard. Would you like to say a few words about his contribution to the world of international arbitration?
That's a very thoughtful and very kind and timely suggestion, Ricardo, and I appreciate it. I'm sure all of his friends also would appreciate that. His contributions, Emmanuel's contributions to international arbitration, both commercial arbitration, investment arbitration, were immeasurable. He was an indefatigable advocate. He was a superb arbitrator. He was a brilliant writer and theorist. He was a great colleague and a good friend. He'll be missed, I think, both on a personal level, but also a professional and a public level by all of us. Definitely,
yeah, definitely, we're going to miss him. I would like to finalize this talk, Gary, with a questionnaire inspired by Bernard Pivot. What is your favorite word?
Oh dear, I should have looked at this. I should have looked at this beforehand. My favorite word right now is sleep.
What is your least favorite word?
Anger.
What turns you on?
Life turns me on.
What turns you off?
Anger again, I think.
What sound or noise do you love, Gary?
What sound or noise? I love the sound of the wind. I love the sound of the rain on the windows. My favorite song is Whiskey Lullaby by Alison Krauss. You all have to go listen to it.
Definitely. What sound or noise do you hate?
Time's Up.
What profession other than your own would you like to attempt?
I would love to be a successful fiction writer.
What profession would you absolutely not like to undertake?
Being a policeman.
All right. And if heaven exists, what would you like to hear God say when you arrive at the pearly gates?
You can have a redo.
All right. Ladies and gentlemen, Mr. Gary Bourne.
Thank you so much.
Francesco.
Thank you, Ricardo. Thank you very much for the invitation. It's a true pleasure being here today with all of you, especially with Gary. I will try not to behave as a groupie, although I certainly am. But said so, there are very interesting questions here from the audience. The first one is, could you share any piece of advice for all those young practitioners aiming to pursue a career in international arbitration?
So that's a good question. It's a really hard question. My advice is sort of several-fold. It's also very boring and probably unwelcome. Always work harder. Never give up. Push yourself to your absolute limits, no matter what. I'm sure that's not very welcome advice. It's probably advice that everybody has gotten from their grandfather or their mother or what have you. But it's still true. Additionally, treat every chance, every case, every opportunity for cross-examination, every time you're trying to clear a new client through your firm's conflicts, new business committee, treat every opportunity as if it were the last one you're ever going to get. You'll never know when an opportunity, a small case, which you didn't think was important, a new client, which you didn't think would ever grow, a new speaking opportunity, which you thought wouldn't be well attended. You never know when that will turn into the most important thing in your life and change the direction of your career.
Wise words. Thank you very much for that. A second question on execution and enforcement of preliminary measures granted by an international arbitral tribunal. Absent any domestic law on the matter, could the New York Convention be enough on its own?
It's a good question. It's one that I've heard a few times in recent weeks. There must be some cases out there where people are trying to enforce so-called awards granting provisional measures. So putting aside domestic law, which might make orders of provisional relief enforceable in some specific way, the question is whether a decision by a tribunal granting interim relief, that means relief that is not final after the arbitration, but that only lasts until the end of the arbitration, is an award or isn't an award. This is important because if it is an award, then it's subject to recognition under both the model law, but also the New York Convention articles 3, 4, and 5. There's a division in both judicial authority, but also commentary about the answer to that question. Some courts, Australian courts, for example, many commentators as well, both in civil law and common law jurisdictions, say that a decision granting provisional measures can't be an award because it isn't final. It's not final because, as we've just discussed, it is either interim or provisional. Other courts and some commentators, US courts in particular, say the opposite. They say that a decision granting provisional relief is final, it may be final in a somewhat different way than a truly final award, but is nonetheless meant to be a final disposition of a request for interim relief, and that all the reasons that you want to be able to enforce a final award are, in most cases, just as applicable to a decision granting provisional measures. I incline towards the latter view. I incline because I think in many cases it makes sense, and that's why the Untitled model law and its revised version of Article 17 provided a standalone mechanism for recognizing and enforcing orders of provisional measures. It makes sense to treat these orders as awards under the New York Convention. Succeeding in that argument, though, is not straightforward. You can cite my treatise, which unsurprisingly takes much the same view, but there's not a whole lot of national court authority that you can cite.
Thank you very much. The third question is, looking at Article 5 of the New York Convention and considering the actual application of the New York Convention in different jurisdictions worldwide, do you think it is possible to speak about a true international public policy concept?
That's a good question, and again, there are different views that have been taken on it. In Article 5.2, there's both a non-arbitrability exception and a public policy exception. The public policy exception permits a state to deny recognition of an otherwise valid award if recognizing the award would conflict with public policy, and then importantly, given the question of the recognition state. That language in the New York Convention pretty strongly points one to the law, the domestic law of the particular recognition form. In a sense, this public policy exception is a kind of escape valve that one sees in other areas of private international law that allows one to escape from the otherwise applicable international obligation to recognize. And in that sense, if one stopped analysis there, the answer to the question would be one shouldn't really develop an international public policy, given the New York Convention, and it's difficult, given that text, in fact, to do so. However, analysis doesn't necessarily need to stop there, because as courts in some countries have done, you can look to how in the national jurisdiction in question, the recognition forum, international matters would be dealt with. And in that sense, there would be a development of an international public policy. That would be particularly true, I think, under the Untitled model law, where the 2006 amendments in particular emphasize uniformity and cooperation between states. The same notions underlie the New York Convention. So as each country applies its escape valve, which the convention gives it, it uses a substantial measure of self-restraint, limiting the application of public policy to deny recognition of foreign awards only to the most essential types of cases. A little bit similar to what the US Supreme Court did in the Mitsubishi Motors case, where it said we could hold that US antitrust claims are non-arbitrable for purposes of Article 5.2, but we won't do it. We will take a very restrained conception of non-arbitrability in international matters. And in that sense, I think the answer to the question is yes, there can be and should be under Article 5 a development of an international public policy.
Francesco, if you allow me, I received a question that I would like to raise, Gary. It's regarding appeal under the Permanent Investment Court. We know your opinion about the investment court. This is the question. To what extent the rules on recognition and enforcement of the award are compatible with an award that has been subject to appeal? Article 53 of ICSID Convention prohibits any other remedy than those provided under the convention.
So I'm trying to think exactly what the question is. I think from first principles, I think the fact that an award is subject to an appeal under both the ICSID Convention, but also New York Convention, doesn't keep it from being an award or keep it from being subject to recognition and enforcement. A number of arbitral institutions, GAFTA, the AAA, have the possibility of internal appellate mechanisms within the arbitral institution, and arbitration being a creature of contract, certainly can accommodate the notion of a first instance arbitration and then a subsequent appellate arbitration. I think in general, parties don't like that. They, I think, regard appeals as inconsistent with the notions of finality as well as expedition and efficiency. In the specific ICSID context, of course, annulment committees are, everybody says they're not appeals, but they're a form of review, which at least in some cases can come pretty close to appeals. The notion that there could be an appeal of an ICSID award to some national court or to the multilateral investment court, I think one would need to flesh out exactly what procedures one is thinking, and likely any such proposal would require amendments to the ICSID convention or perhaps other conventions.
Okay, I think we're on time. Yes, sorry.
The last one?
Yeah. Excellent.
The last one, short and interesting for everyone, I think. Any tip regarding advocacy in international arbitration?
So there are different kinds of advocacy. There's written advocacy and there's oral advocacy.
Right.
I think the tip for both is it's impossible to over-prepare. Knowing in the most humanly possible detail what your case is, paying attention to who your tribunal is. Remember, you're talking to people. You're not talking to yourself. You're not talking to your client. You're talking to one person, three people, however many people. And you need to make sure they're really listening to you. Which, given how long some of my answers have been, I'm sure nobody is doing with me at the moment.
Oh, no, that's not true.
Thank you very much. Thank you very much, Professor.
No, thank you.
Okay. Thank you, Gary. Thank you, Gary, for your time, for your answers, for all your knowledge that you have shared with us. Thank you, everybody. We look forward to seeing you in the next conversation. Good evening. Thank you very much again.
Thank you, everyone. Thank you, Ricardo.